When I tell you to do something, you do it. End of story. Step out of the car. Turn around. Hands on the hood. Hands on the roof. Sit down and shut the up.
Why do you think that throughout your career you have continued to be accused of excessive force?
You will not get up without our permission. Man, sit the down.
In his 12 years on the job, this Melvindale, Michigan police officer has been suspended, criminally charged, fired, and then brought back.
The defendant used coarse language, threw a food bowl across a kitchen.
Do you think he understands de-escalation?
Oh, no, I don't.
So why is he still there? Lieutenant Matthew Furman says that the only reason there have been so many allegations against him is because he's, quote, proactive about stopping crime.
Why do you think that throughout your career you have continued to be accused of excessive force?
I think I'm very proactive, and I think I'm involved in a lot more scenes and incidents. If you are proactive and you're hardworking, you are going to get more complaints.
But these aren't just complaints coming from citizens. These are, in some cases, complaints coming from other officers in your department, officers in other departments, your chief in some cases. That's not typical, is it?
I don't know.
He's currently under investigation by both the Michigan State Police and the Melvindale Police Department over a traffic stop that escalated to him tasing the driver.
It's under investigation at this time, and it will be continued to be investigated and thoroughly done.
Officer Furman maintains that he did absolutely nothing wrong. He says it's just another false claim.
Do you have the temperament to be a police officer?
I do.
A lot of people don't think so. Some people in your own department, in fact.
And I've had a lot of people tell me I'm a great police officer.
Before we get to the most recent incident, let's take a look at Officer Furman's history. In 2016, Furman pulled over a mother who was driving her two small children. The vehicle had no insurance, so he ordered the car towed. The woman claimed that instead of letting her wait for her ride to come pick her up, Furman instead dragged her out of the car and onto the ground and forced her onto the vehicle's hood right in front of her children as they watched. Officer Furman did get a 3-day suspension over that. However, that suspension was later overturned by the ironically named Public Safety Commission. A few months later, Furman detained a robbery suspect who alleged that he, quote, slammed his head into a police car while he was handcuffed. But they didn't just have to take that guy's word for it. A lieutenant reported that he witnessed that, and he told the victim that he would, quote, not sweep that incident under the rug. Another officer who was there said under oath that Officer Furman went, quote, way over the line and split the man's head open. But Furman himself told 7 News Detroit that he did nothing wrong. He said that the two officers were mistaken.
Furman told us he didn't cause the injury at all. It was the people the man was stealing from. He said the two officers didn't see what they thought they saw.
They're both lying.
I'm not going to call them liars, but I'm going to say their perspective was probably off because they were halfway down the block.
The former Melvindale police chief, his former boss, said that he tried to rein Officer Furman in, and he ended up getting terminated as a result. In a 2017 lawsuit, that former chief said that Furman, quote, engaged in repeated incidents of police brutality, but that he was discouraged from actually holding him accountable because the city was making such a large amount of money from Officer Furman's repeated towing of citizens' vehicles. In 2019, Officer Furman was criminally charged with assault in Wayne County, Michigan, after he responded to a disorderly conduct complaint. He was accused of throwing an intoxicated man down a flight of stairs. Furman, of course, denied those charges, and he claimed that the man just fell on his own. But then Furman apparently took a plea deal where the assault charge was dismissed in exchange to him agreeing to the conviction of, quote, willful neglect of duty.
Our other top story at this hour, a Melvindale police sergeant pleading no contest to a charge of willful neglect of duty.
Sergeant Matthew Furman made the plea during an arraignment this afternoon.
Do you solemnly swear and affirm that the testimony you're about to give concerning this case will be the truth, so help you God?
Yes, sir.
The defendant used coarse language, threw a food bowl across a kitchen, and acted in an unprofessional manner.
Set free on personal bond, he will be required to serve a year of probation, attend anger management classes, pay fines, and restitution. His formal sentencing date has not yet been set.
He was then fired. However, an arbitrator later overturned the termination. Now Furman is telling the news media that he has now withdrawn that no contest plea to that conviction. 2 years later, Furman was part of a high-speed police chase. The suspect had stolen a vehicle, the police said, after striking an officer. Then after his vehicle crashed, he fled on foot before police officers eventually surrounded him. As officers from multiple agencies tried to subdue him, a Dearborn police officer's body cam caught Officer Furman repeatedly stomping on the man's leg. We actually see the officers warning each other that they're being recorded via body cam. Then they stop.
Cameras all around, guys.
A Dearborn officer then reported Furman's use of force to the Melvindale police. But Furman told 7 News Detroit that the man was resisting officers as they tried to handcuff him, so he used the stomps as a form of pain compliance. Furman did not receive any discipline for that. And remarkably, the town's mayor, who employs Furman as a police officer, has said on the record that Furman basically just can't control his anger, doesn't understand de-escalation, and that he's better sitting at a desk than out interacting with the public.
Do you think he understands de-escalation?
No, I don't. I feel like in the heat of the moment, he needs to learn how to put aside anger and just do his job.
When we talked to her last month, she said Furman belongs at a desk rather than on the street, that at least one lieutenant in the department doesn't want to respond to calls with Furman, concerned that they'll end in trouble.
When you have other officers saying that they don't want to respond to calls with him, that can potentially cause a problem.
And Officer Furman's temper is the reason why he's now back in the spotlight. On July 20th, Furman stopped the vehicle driven by Drakkar Williams for driving around traffic barricades. Also in the vehicle was Williams's girlfriend and 2 small children, ages 2 and 5. Williams' driver's license was suspended. The vehicle he was driving had no valid insurance. And when Furman asked him for his name, he provided a fake one.
You have a driver's license?
I don't. My mother actually just got in an accident.
Do you have a license?
It's at the house.
And it's true that Williams was told more than once to get out of the vehicle.
Go and step out of the car for me.
And why am I stepping
Because you're refusing to provide information.
I
asked your middle name. That is relevant. You're refusing to provide it. Step
cooperating.
out of the vehicle now.
I'm not coming out? Yes.
Next thing is you get tasered. Get out of the car.
This is all standard stuff. Obviously, he needs a license, he needs insurance, and the officer's allowed to order him out of the car. The issue is what happened after he got out of the car. As this is going on, a second officer arrives at the scene. Furman ordered Williams to turn around, put his hands on the roof.
Turn around, hands on the roof.
Can you tell him to calm? Can you tell him?
I said hands on the roof. Stop or you will get tasered. When I tell you to do something, you do it. End of story.
And at that point, Furman's partner can be seen holding Williams's right hand and shoulder. Within seconds of ordering Williams to place his hands behind his back, Furman then suddenly uses his taser in drive stun mode and starts tasing Williams repeatedly.
I'm not.
Hands behind your back. Interlace your fingers. Hands behind your back.
Furman later claimed that he continued to tase Williams because he believed that Williams tried to grab the taser.
Cooperate.
What am I doing?
Cooperate.
What am I? I'm not doing nothing. You take up. Stop.
Stop.
I'm not doing nothing.
Stop.
I'm not doing. What am I doing? You take.
Stop moving.
After Williams was in custody, Furman turned his attention then to his girlfriend, who he said posed a threat while she was seated in the vehicle and that she needed to be detained.
Get out of the car now. Get out of the car. Step out of the car. Turn around. Hands on the hood. Hands on the roof. Step over here. Step over here. You're being detained right now.
I'm being detained. I'm trying to make somebody.
Sit down and shut the up.
But most likely he had just once again lost his temper, and the fact that she was recording him just sent him over the edge. Seconds later, he can be heard arguing with Williams once again while Williams is handcuffed on the ground and at one point calling him a retard.
And then you would get out of the car. And then you would put your hands on your back.
Get out the car?
It's on video, retard.
You a retard?
Yeah.
Furman then heads to his vehicle. He determines Williams' real name. Then after reviewing his criminal history, Furman approaches Williams while he's handcuffed and sitting against a fire truck.
You got a revoked license, so you should have been behind the wheel. You got a ton of warrants. And now you got obstructing and resisting and everything else.
You gonna lose your badge.
I ain't gonna lose. You're gonna lose your freedom because you get to go to jail today, mother.
After Williams stands up, another officer sits him back down. Then, with Williams still in handcuffs, Furman grabs him by the back of the hair and pulled his head into the fire truck.
You will not get up without our permission.
Man, I gotta
sit the down.
I am sitting down. You pulling my hair.
Furman explained that Williams posed a risk when he stood up, making the force used appropriate. Though the video shows that while he stood up, he was set back down by the other officer. Rather, it just appears that once again he's unable to control his temper.
I gotta
sit the down.
Throwing my head against a fire truck while I'm in handcuffs, I can't do nothing. I'm helpless.
My priority is doing whatever I have to do to go home. And if that means somebody gets tasered, then somebody's getting tasered. But I'm going home to my family and my friends. That's my number one goal.
And that, coincidentally, is also the number one reason why he does not have the temperament to be a police officer, because he has his priorities mixed up. In my opinion, the number one reason that you have all these videos, all these incidents around the country is because you have this attitude in certain police officers that they don't care if they arrest an innocent person. They don't care if they harm an innocent person or shoot the wrong person or raid the wrong house or all of these things that they have done. This is a job to them, and their number one priority is their own safety. It's not their oath to any constitution, to any government, to the community. It's their own self-interest. And guys like this, when you challenge their authority, in their minds, you're challenging their own self-interest. You're challenging their family. Guys like this are not serving the public. They're not public servants. This is a job to them. You just comply or else. One thing I've seen over the years is that, yes, people can lie. There can be three sides to every story. But when you have years and years and years of multiple allegations, where there's smoke, there tends to be fire. So why is this guy still here? How difficult is it to get rid of a police officer in Melvindale, Michigan? I mean, this guy got prosecuted, he got fired, yet some arbitrator says he gets to come back. His former police chief couldn't fire him. The mayor admits that he's not a good cop, but she can't even get rid of him. What's missing here? Why is he still here? Because a total lack of accountability. And that's what needs to change. Let me know your opinion on what you've seen here. Do you think that Officer Matthew Furman is a good cop? Do you think he has the appropriate temperament to be a police officer? Let me know in the comments. Please subscribe both here and at the blog at thecivilrightslawyer.com. Also follow me on Twitter at JohnBryanESQ. Remember, our rights don't end where you're still beaten by 2 Kentucky state troopers. Then the dad goes on to get his cell phone and he starts filming or attempting to. The troopers then took the phone and deleted the footage. Well, as sometimes happens, the parents had interior surveillance cameras that the cops did not know about. My buddy Chris Wiest filed a lawsuit against them. He puts them under oath at their depositions and then he asks them about it. Both troopers denied even striking the guy.
Once you had him on the ground, did you strike or hit him with a closed fist at all?
No, sir.
Or any part of your body?
No, sir.
Okay.
Unfortunately for them, they had been caught on camera and Chris had the footage. I got the opportunity to talk with Chris this weekend about a few of his cases, including this one. Again, this is breaking news. This case just settled. I actually saw it in the news first, and then I texted Chris and said, hey, congrats on the settlement. I'll let him tell you about it, along with some of the other interesting details about this case and about suing the police in general. But here's what happened. On April 9th of 2020, Kentucky State Troopers James Cameron Wright, Thomas Zartorsky, and a third trooper, Kevin Dreisbach, went to the Hornbach's home in Shepherdsville, Kentucky, to arrest 29-year-old Alex Hornbach for a missed appearance in Jefferson District Court. Hornbach's mother and father met the cops at the door, and they led Wright and Zartorsky to the basement of their home where their son was, while Dreisbach covered the rear of the house. Zartorsky and Wright testified in their January of 2021 depositions that they had a relatively calm interaction with Hornbach, despite taking him to the floor, and that they did not use any other force or strike him. The Hornbach's lawyer, Chris Wiest, later released home security video contradicting the troopers' statements, i.e. showing that they lied. The video showed Wright grabbing Hornbach around the neck and slinging him to the floor, though Hornbach was not visibly resisting. The video also showed Zartorsky striking Hornbach 4 times on the legs with his flashlight. Wright hit Hornbach twice in the back with his right forearm and appeared to have his left knee on Hornbach's neck, pushing his face into the floor. Hornbach did not suffer any serious injuries. Only one of these state troopers would continue to be a state trooper after this. But let's hear from Chris. Give me a recap of this Sartorsky case that you've been litigating for so long.
Well, we litigated that up to, I mean, it was like a week or two before trial, and I wanted to try the case. My co-counsel wanted to try the case. It's been reported now in the news. They put, $135,000 on the table, and the clients wanted to take it. And,
I know we talked about this before. Could you just briefly explain again in the Sartorsky case, the video, what happened?
Well, Dad had the basement video. The other side did not require production of what we had in our files prior to taking positions under oath. And I got early depositions of these troopers, and they lied about it, not knowing that we had video of the incident because they thought that they had deleted it off of Dad's phone. So they thought they were clear, and they thought they had successfully covered it up, and turned out they didn't. So clients make settlement decisions, and the Hornback family did, and it got settled for what it got settled for. So I thought it would have been a really fun case to try from my perspective, but clients make settlement decisions, not lawyers. So.
Well, it's got to be a fun case to try where the defendant has been charged with perjury. Right?
Yes. And I thought it was, there were some other aspects of that. I mean, there were two troopers who were part and parcel with all of it, and they were scapegoating the guy that got charged with perjury. And I felt like the other two had just as much culpability in it and, weren't being charged with perjury. And the guy that was being charged with perjury was being scapegoated because they were all kind of in cahoots. They tried to exclude prior incidents of use of force from these same three. There was sort of a pattern in the month prior, and the judge was going to let that in. So there was some in limine practice on that. We got in limine rulings. Mom's claims got tossed. She was unlawfully detained outside. We were going to take that up on appeal. They were going to let in parts of the client's criminal record, which, gets into the he had it coming defense, which they were going to try and use. So, all of them, it's a typical use of force case. I have yet to do a use of force case in which, to some degree, the client, through their conduct, did not in some way have some involvement with it, right? Because if you just roll over generally and you're just, there's absolutely no pushback, they'll come in, they might rough you up a little bit, but it doesn't really, usually there's always something, either words or something else that precipitates these folks to lose their cool and engage in the excessive use of force in my experience. And so I, to some degree, he had a coming defense, it was going to be a play in Hornback. I have yet to do a use of force case where there's not some attempt by the defense to argue he had it coming.
Why did the judge allow some of your clients' criminal history to come before the jury? Is that because the cops were aware of it at the time the incident occurred?
Yeah, that was it. The cops said they were aware of it, and that factored into their apprehension about the client. Was what they said.
And why is that? Did it have to do with potential violence against police officers?
No, what was interesting? I mean, she tossed. So he had some drug stuff. She tossed all that. She said that's not coming in. He had a prior fleeing and evading, not a conviction, but a charge that he denied. And she was going to let that in. And I'm like, how in the world are you going to do that? I mean, but, I think the conviction for fleeing and evading would have been, that would have been probably valid. But she was going to let a charge in that was dismissed. And I'm like, Judge.
So how many defendants were there in this case?
Three.
And so the one could be seen in the video hitting the guy with the flashlight, that's the one who got charged with perjury and fired.
Right. That's Tom Zortorsky. Yep.
And he was fired while your case was pending before trial.
Right.
So did he get thrown completely under the bus as far as insurance coverage goes?
So, that's interesting. There is no insurance that any of these guys have. The state, it's whether or not the state's going to indemnify them. There's an indemnity statute on whether or not, the state judgment fund is going to be used to satisfy those claims. And in this case, they were always, that was why I think we got the case settled for what it settled for, because the defense was always sort of rattling the saber of no indemnity, no indemnity, no indemnity. Good luck collecting your judgment, which, to which I said, that's fine. These guys make a paycheck. I'll take a quarter out at a time, because you could take a quarter of their paycheck out every pay period. That that's always an issue sometimes with suing the state police versus the municipal police. because there's usually not private insurance coverage. It's always just a state indemnity fund, and they raised that they did here.
So after that guy was fired, I mean, did they provide his defense lawyer?
They did provide a defense. They were saying they were not going to provide indemnity, actual sort of payout of the judgment or attorney fees and costs and that kind of stuff.
So in the media report that I saw, it said that the case settled for $130,000, and then $5,000 of that was to be paid by Sartorsky.
No, it was $135,000. I thought it was $130,000 plus $5,000 out of his pocket.
Kentucky State Police will pay $130,000 of the $135,000 settlement, and the remaining $5,000 to be paid by Thomas Zartorsky.
Right.
Why $5,000 from him? How'd that come up?
Well, we demanded that he come out of pocket for it, because I said I'm going to hit him with punitives. He's going to come out of pocket for it when I hit him with punitives. Something's coming out of his pocket. So they said, we're not putting any more state money in other than $130,000. And I said, well, I'm going to send a message, and the message is $5,000 out of his own pocket.
And what about, I know there were a couple other videos, right, of Sartorsky hitting some other people.
Yes.
Was any of that going to be allowed to go to the jury?
Well, we could use it. Yes. She said we could get those prior incidents in. Yes.
What was the legal basis for that?
Pattern and practice, lack of mistake. Yeah, I mean, we argued all of the exceptions to the prior, where you can't say he did it before he did it again. But so we argued, they argued it should come out under 404A and B. We said we're not going to use it in terms of acts of conformity. We're going to use it under 404B2 to prove motive, opportunity, intent, knowledge, absence of mistake, and lack of accident, and which are all Rule 404B. And then we said all of this goes to the heart of the punitive damages case, namely that these guys were motivated by an evil motive or intent, or at a minimum acted in reckless or callous indifference of the protected rights. And so, she said we got to get it in. So,
well, that's a big win, because I know they always fight me hard on that, trying to keep out any of that, any of those prior allegations.
So I think that the timing mattered a lot. The fact that this was done in the month prior, and at the time he was under a use of force investigation for those prior incidents at the time they did this and at the time they deleted the footage. And what I argued in part was, look, this is why they ordered the footage deleted, because he was already under investigation. So we have to be able to talk about it. And she agreed.
Now, the other two defendants, are they still employed at the Kentucky State Police?
They are.
Or were they disciplined at all? Do you know?
Well, I don't believe so.
And presumably they didn't have to pay any portion of that settlement.
Correct.
How close did you guys come up to trial?
We were about a week away. I had booked. I mean, we had expert travel arrangements. We had booked hotels. We were prepared. We were prepared. I mean, we were prepared to try it. I had my opening statement ready. We had our cross-examinations ready. We had our witness outlines ready. We were ready to try the case.
And did they just wait to the very end to really come to the table?
I think so they started to put real money on the table in about a month out. And we're like, it's not enough. It's not going to get it done. And there was some back and forth where they went back to go get more authority, and that didn't get it done. And then when they realized we were really serious and we were going to try it, then then we got over six figures. And then it was just a matter of, seeing where, how close we were going to get. And I would say it was probably a couple weeks out. I thought it was probably going to settle. I start prepping about a month out. Like once I get my eliminate rulings, I know what's coming in and what's not coming in. That's when I start my prep for trial.
I think one of the most confusing things about these types of Section 1983 excessive force cases is how are they valued? Negotiating back and forth where you have the insurance adjusters on the other side that they're only interested in are there any medical bills and things like that. And obviously we're looking at it from a different point of view. I mean, how do you argue for, valuation of a case like this where a guy has been beaten, but he doesn't have any severe injuries?
So, I don't overvalue that. If there's not, we had photos of bruising here, and I put a number on that in, the $10,000 to $15,000 range. And then I thought, well, it's probably going to be another $15,000 to $25,000 in punitive exposure. I thought was probably where we would end up on the punitive exposure. But what drives these settlements, particularly at the 11th hour, is the fact that they know that we had Lodestar time for the people that are watching this channel. that's the attorney fee time. And there's attorney fee shifting where they have to pay the other side's attorney fees. And we've got my co-counsel and I know you do in West Virginia, we have fairly well-established rates that, because we do enough of this work where courts are awarding fees with some regularity. So we know what our hourly rate is. We know what courts have approved for that hourly rate. It's a matter of the number of hours we had in the case. And I will tell you, like, we had our attorney fee time was going to be substantially higher than what we settled this case for. And I felt like we were going to get a verdict on the underlying liability, and the attorney fee award itself was going to exceed it. Now, from the client's perspective, if it goes to trial and we get an attorney fee award, we have the option in our fee agreement of keeping the attorney fee award. They keep what the jury gives them. And so they were going to not make as much money on the case. And, they kind of made some money off of our attorney fee time. And I think that was a huge driver in this case. And, that sometimes, unfortunately, is on some of these where you've got like a soft tissue injury and you don't have hospital bills. And I think the other side fully appreciated the attorney fee exposure. I had a case in 2019. Client, gave a state trooper a one-finger salute. And you can imagine what entailed after that, which was a wrongful arrest, a wrongful stop, wrongful charge, ended up getting tossed in state court at a preliminary hearing of all things, allegedly assaulting the officer because he was trying to record the interaction by pulling the phone away. It was just, kind of a bad deal. The jury gave the client $800. And the defense attorneys were like high-fiving each other on the way out. And I'm like, well, that's a bold move, Cotton. Wait till you see the fee award. And, it was almost like $100,000 in fees that the judge awarded and, attorney fees and costs. Now, the client didn't get that. We got that. And, I think the state police had been down this road with us before. And I think they knew, I don't think they were particularly afraid of the client's damages. I think they were afraid of getting hit with the six-figure attorney fee award. And it would have been every bit of that.
Now, was there a claim made related to them deleting the video?
I mean, we argue, we argue the unlawful seizure of Dad's phone and the unlawful deletion of the video, which was a Fourth Amendment seizure we claimed, and the judge agreed that could go to the jury. We also asked for a spoliation instruction, and that was, I think, likely to be instructed to the jury too. The whole, you could assume, because they deleted the evidence, would have been highly unfavorable to them. You should make that assumption. I'm instructing you to do that because they spoliated evidence. And so we asked for that instruction as well.
Did any of the other defendant officers get caught lying under oath in this case?
Zertorsky obviously, I think, was the most blatant. Cameron Wright said that he didn't use any force on Hornback, and obviously, you saw that strike to the back of the head or neck. So that was not truthful. He was not charged for it. But obviously his testimony was inconsistent with the video. So, and nothing's happened to him as a consequence of that.
Did the feds ever show any interest, can you say, in investigating these guys?
I would not be allowed to comment about things that I might understand are still active federal investigations, and just let me leave it at that.
So there you have it. Accountability has been achieved. It wasn't perfect, and it never is. But it's the remedy available to us, and it was actually pretty successful in this case. The best thing that you can do is share this footage and this news far and wide so that as many people as possible see it and hear about it. That is what the government fears the most. As always, thanks for watching. It's always a fantastic opportunity for all of us to hear Chris explain what he's been up to in these cases. And again, if you search past videos on this channel, you'll see some of our prior conversations, including several videos about this one, I believe. Now, Chris practices both in Kentucky and Ohio, so if you're in need of a civil rights lawyer in those states, that's who I would try first. I'll put his contact information in the description. I get a steady stream of calls from people all over the country searching for a civil rights lawyer. As I said in the last video, I only handle cases in West Virginia. If you watch my channel, you know that I have my hands really busy here in West Virginia. I am working on compiling a referral database for all 50 states. So if you're a civil rights lawyer in a different state or you know of one, please let me know and I'll include you or them on the list. And if you have a West Virginia matter that you actually want to speak to me about and I can handle for you, I do have a limited number of consultations available each week that I try to do. Sometimes I can't. So if you're interested in that, I do have an actual office with people answering the phones who can set you up. Please be polite to them or you will not get through. If you enjoy this type of content, reviewing police interactions, discussing constitutional law, please subscribe and keep the channel growing almost to 250,000, and I really appreciate it.
The owner of the YouTube channel Accountability for All was filming a response by the Boston Police Department in Boston, Massachusetts when he encountered Officer Thomas Antonino. Mr. Abrams filmed the interaction that followed and shared it on his YouTube channel.
Okay?
All set.
Huh?
Good to go.
Why are you filming the ambulance? Any reason?
Does it feel like it?
Feel like it?
Yeah.
Gotta get a life, bud.
Gotta get a life?
Midnight filming.
Define life.
Good job.
Hi.
All right.
So you're saying I sell drugs? Now I can have a check, guy. Huh? Just pull out my camera. And look at you. What's your name, dude?
Officer Antonino.
All right, so that's how you treat people? We're exercising a constitution-protected activity, and you say because of the time limit I must be selling drugs?
Listen,
Step the back.
First of all, I don't know who you think you're talking.
I'm
Get on the
talking to you.
sidewalk.
I'm
Get
talking
on the
to you.
sidewalk.
You're on the
Get on
road.
the sidewalk.
You're on the road.
Get on the sidewalk.
You get on the sidewalk.
Get on the sidewalk.
You get on the sidewalk. You have no idea who you're dealing with, do you? Yeah, see? De-escalate. Listen to your partner.
I am.
He's going to make this video much shorter.
You're the one
Let's get what
escalating.
you got on your screen there. Let's make sure we get everything on your screen.
Yeah,
Oh,
you're not the
perfect.
one escalating.
Perfect. Shut your mouth and get moving. I don't feel like hearing your bull. F off.
Are you a police or an EMS or just an I just wondering.
He's a bag they made the mistake of giving a badge to. Get a life, get a job, bro. Listen, let's compare paychecks, dude. I'll retire next year. I'm 32. How old are you, asshole? Put your window down. Try and get one last word in. Bye, Felicia. Yeah, don't crash into anybody. What are you, drunk? He knows that this is going. He knows who I am. He knows that this is going to go on YouTube. He knows because of who I am, this is going to make a ton of views. And now he's covering his because his partner made him look like a bag. That's what's going on right now.
Mr. Abrams encountered Officer Antonino again 2 years later on September 1st, 2022, as he was filming in South Boston with the owner of the No Name Audits' YouTube channel. According to Mr. Abrams, he began to film Officer Antonino after he heard him direct profanity at an elderly woman. The encounter that followed was captured by Mr. Abrams and No Name Audits, and once again, Mr. Abrams shared it on his YouTube channel.
No parking, huh?
Hey, what's up?
What's going on, man?
You gonna start again?
Huh?
You gonna start again?
Start what again?
Why are you filming?
Because I feel like it. Why don't you shut your mouth? Get out of the handicap place.
Buddy, didn't you learn the last time when you went to jail for robbing someone? Didn't you learn the last time?
Why don't you back up?
Now
Don't
you
touch my
back
camera.
out. Now you
I'm
back
live.
out. Now you back
Yo, I just got that. I just got that.
Back out.
I just got that.
Good, you got it. Good. Back up. Back the f up. Get away from my cruiser.
I didn't go near your cruise. I was making sure you didn't hurt my friend.
I'm talking to him. All right.
Why would you touch me like that?
Did you put the camera in my face?
I'm sitting on the sidewalk. You're live.
You put the camera in my face.
Buddy, you're live on 2 cameras.
Listen, you
Filming, that's not trouble, buddy.
Huh?
I'm sitting on a public
Why are you
sidewalk.
coming to my window and taking video.
Is that
for no
illegal?
reason?
Is it illegal to go like this, Sergeant, Officer? Is it illegal to do that?
You're making a thing. Am I in the handicap spot? No.
You're in a no parking
you have
zone,
no clue
are
what
you?
you're talking about.
Dude, first of all, why don't you get in your car and leave? You just
Listen,
assaulted someone. Could I have a supervisor, please?
Want me to go live?
Yeah,
Yeah,
go
go
live.
live.
Go live.
Could I have a supervisor, please, man? Oh, that's professional.
Before we continue the interaction, I want to give a big thanks to the sponsor of this episode, Incogni. Most people don't realize how much of their personal information is exposed online until they see it for themselves. A quick Google search of your name, city, and state will usually turn up dozens of sites listing your address, phone number, email, and more, often without your consent. That's information that can be bought, sold, or misused by anyone with an internet connection. Incogni is a service that works to remove that information from the internet. Their team targets data broker sites, people search engines, and other databases that profit off of your personal data. The Incogni team have now expanded their capabilities with a new feature in their unlimited plan called Custom Removals. This allows you to submit an unlimited number of links to websites where your personal information appears, even if those sites aren't part of Incogni's automated removal network. You paste the link into your dashboard, Incogni reviews it, and if eligible, their privacy experts work on getting it taken down. Incogni also automatically works through hundreds of major data broker broker databases on your behalf, sends follow-up requests to ensure removals stick, and continuously monitors for new exposures so your information doesn't resurface. It's a hands-off system designed to keep your data cleaned up and locked down. Incogni is the first and only personal data removal service to be independently verified by Deloitte, which is one of the most well-respected professional services firms in the country. Right now, Incogni is offering members of the ATA community a 60% discount on an annual plan when you use code THEAUDIT at the link below. Data doesn't just disappear on its own. If you don't take it back, someone else will. Thanks again to Incogni for sponsoring today's episode.
Can I have your supervisor, please? What's your name, man? What's your name? What's your name, buddy? What's your name? You assault citizens like that? What's your name, man?
You guys rolling the fuck up like that?
What's your name, man? Did you get that?
Yep. Hey, what happened? That's my college. Anything happening?
No, they're just assaulting people.
Yo, guys, the cops have attacked AFA. No needs even.
D4, right? So we'll see you guys. We'll see you guys down there. We'll see you guys down there, right? Camera's very scary, isn't it?
There's another one. There's a mocked out right there. Yo, the cops have attacked AFA. I got it on my screen record. I ran across the street. I don't care.
Lawsuit. Lawsuit, buddy.
Grab your camera, everything. Hey, Josh.
All right, guys, we're going to the precinct.
After Officer Antonino grabs Mr. Abrams' hand and camera, Mr. Abrams indicates that he's going to file a lawsuit and go to the precinct to file a complaint. The First Circuit Court of Appeals, which has jurisdiction over Massachusetts, has recognized strong protections under the First Amendment for recording the police in public. In the 2011 case of Glick versus Cuniff, a bystander was arrested after using his cell phone to film Boston police officers roughly arresting a suspect on Boston Common. The First Circuit ruled that this arrest violated the First Amendment because citizens have a right to record public officials, such as law enforcement officers, performing their duties in public. 3 years later, in the 2014 case of Garrick versus Begin, a woman was arrested in New Hampshire for recording a late-night traffic stop, and the First Circuit again held that the First Amendment protects the act of filming the police in public so long as the individual is not interfering with the officer's duties. Together, these rulings make clear that members of the public can legally document police conduct in traditional public spaces as an exercise of free speech protected by the First Amendment. As such, Mr. Abrams would have a strong argument that Officer Antonino's conduct was unconstitutional, as it interfered with his First Amendment right to film from a public sidewalk, and he did not impede Officer Antonino in the performance of any duty. Additionally, Mr. Abrams could also argue that Officer Antonino's use of force violated the Fourth Amendment, as it was constitutionally excessive. As we have discussed before here on ATA, when police do use physical force, the Fourth Amendment requires that it be quote-unquote reasonable under the circumstances. Because Mr. Abrams' actions in filming Officer Antonino were protected by the First Amendment, there was no legitimate justification for employing force to stop him from recording, and therefore a court would likely find that the use of force was gratuitous and unreasonable.
Now, guys, we're headed down to the precinct to file a complaint. This guy's driving up and down the street. Up and down the street.
He's going to harass. Guys, don't call D4. I mean, this guy needs to hit that like button, hit that subscribe. He pulled over because he was harassing all the homeless over here. 2 units were harassing homeless.
He's flipping again.
Flipping again? You told me to go near my car. What do you want to fuck? He's gonna go over there and fuck.
This guy's crazy, huh? I don't know change. Look at this guy, crazy. Gang stalking. That's gang stalking. Look at this guy. He keeps driving in circles. Back and around.
How do you pass the psychological evaluation? How do you pass the psychological? How did you know? You need the out, buddy. How did you pass the psychological evaluation?
As Mr. Abrams walks to the precinct to file a complaint, Officer Antonino circles the block several times, presumably to continue to observe or conduct surveillance on Mr. Abrams. As the Supreme Court noted in the 1967 case of Katz versus United States, individuals have no reasonable expectation of privacy in their movements or actions that they expose to public view, such as on a public sidewalk. Police officers, therefore, have the authority to observe people in public spaces, for example, by circling a city block in a marked patrol car, without implicating the Fourth Amendment, as such casual visual surveillance from a public vantage point is not considered a search and triggers no constitutional requirement of reasonable suspicion or probable cause. However, under these circumstances, it is certainly arguable that Officer Antonino's actions constituted First Amendment retaliation. As the First Circuit Court of Appeals explained in the 2011 case of Hannon versus Beard, a citizen must prove 3 elements to succeed in a First Amendment retaliation claim: that they were engaged in activity protected by the First Amendment, that a government actor took some adverse action against them that would chill or silence an individual of ordinary firmness from continuing to engage in that protected activity, and that the adverse action was motivated at least in part by the protected speech or conduct. Well, here, peacefully walking to file a police misconduct complaint clearly constituted protected activity, and if Officer Antonino was circling the block in an attempt to intimidate or punish Mr. Abrams for his speech, well, then a court could potentially find that such surveillance could dissuade an average citizen from filing the complaint.
We're going to the PD, guys. Stand by. I'm just gonna... All right, I'm gonna fill this out. All right. No. I don't know. I got to run to the car real quick.
I'm not gonna take that the complaint. All right.
You're not gonna take it?
No.
How can you not take a complaint against an officer that assaulted someone?
He didn't assault you. I mean, you went over there. You started harassing him. You know.
By standing on a public sidewalk?
You started talking to him and all that stuff.
But that's legal,
yeah,
man.
But you're looking for a fight.
I'm not looking for a fight.
You weren't looking for a fight.
I'm being very polite to you, aren't I? I'm being very polite to this officer, right?
I'm being polite to you.
Fine. Well, I would like a complaint for him.
All right. Well, you can go to headquarters or something. I'm not gonna take it there. All right.
What's your name? So you're refusing my right to fill out a complaint?
Yep.
I'll go to headquarters.
Mr. Abrams went to the police precinct to file a complaint against Officer Antonino, but the lieutenant that he spoke to refused to accept his complaint. On August 20th, 2024, Mr. Abrams filed a lawsuit in the Suffolk Superior Civil Court, and on September 9th, 2024, the case was removed to a federal court. The complaint alleged, among other claims, violations of the First and Fourth Amendment and requesting $400,000 in compensation. As of the date of writing this episode, the case is still pending. Overall, Officer Antonino gets an F for blatantly interfering with Mr. Abrams' First Amendment right to record in public, using unnecessary and unprovoked force against Mr. Abrams, and for maintaining a hostile and belligerent attitude throughout the encounter. The First Circuit in particular has made it abundantly clear that filming police officers in the course of their duties is a protected act under the First Amendment, and there is no legitimate excuse for any officer within that circuit to believe otherwise. Officer Antonino also inexcusably grabbed Mr. Abrams' phone and attempted to twisted out of his hand, implicating Fourth Amendment protections and likely committing assault and battery under Massachusetts law. It should also be noted that Section 6.04 of Title 550 of the Massachusetts Code of Regulations states that officers cannot use any amount of force unless it is necessary to effect a lawful arrest or detention, prevent an escape from custody, prevent imminent harm, or defend against an individual who initiates force against an officer. Now, because Officer Antonino was not acting according to any of the permissible justifications for force, it is likely that his use of force also violated Massachusetts state law. Officer Antonino's decision to follow and surveil Mr. Abrams after the interaction is also highly questionable and adds credibility to the argument that his actions were intended to chill Mr. Abrams' speech. Furthermore, the supervisor who refused to accept Mr. Abrams' complaint likely violated Boston Police Department Rule 109 regarding discipline procedure, which has been in effect since April 12, 1983, and requires that all complaints be received and recorded courteously, and specifically states that, now quoting, "No citizen shall be denied an opportunity to register a complaint." The rule also indicates that when an individual walks into a station to make a complaint, they must be directed to the nearest available supervisor, and the officer recording the complaint must complete a complaint form after obtaining as much information as possible from the citizen. The BPD officers engaged in what appeared to be a deliberate attempt to violate Mr. Abrams' constitutional rights at nearly every level. This interaction highlights how quickly a routine exercise of free speech can escalate into physical confrontation, and the detrimental effect that institutional stonewalling can have when officers disregard constitutional boundaries and accountability protocols. Mr. Abrams gets an A, because although he was somewhat combative, he remained well within his rights throughout the encounter, remained relatively calm despite the physical altercation, and followed up this interaction with the proper legal action. Even when confronted with aggression and intimidation, Mr. Abrams maintained composure and adhered to the boundaries of lawful conduct. He exercised his First Amendment rights responsibly, did not obstruct any legitimate police function, and pursued redress through the appropriate legal channels. Mr. Abrams demonstrated a clear understanding of both his rights and the proper avenues to assert them, and his decision to bring a civil case against the department further reinforces his commitment to lawful accountability. While his tone may have been sharp at times, it never crossed into illegality or disruption, and under the First Amendment, even strong criticism of government actors is protected speech. In a climate where many auditors blur the line between expressive activity and unlawful conduct, Mr. Abrams kept his footing squarely within constitutional boundaries and is still pursuing accountability nearly 3 years after the interaction. I commend Mr. Abrams for exercising his rights responsibly and for adamantly pursuing justice through the courts. I will leave a link to Mr. Abrams' channel in the description and in a pinned comment if you'd like to support his work. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.
Lisette Gonzalez was arrested for driving on a suspended license. At her trial, a jury had found her guilty, and Judge Fred Schott had handed down a sentence until he began reading into her previous DUI arrest that suspended her license in the first place. As it turns out, Officer Michael Wagner testified that he saw Miss Gonzalez drinking from a can of natural ice while driving. Officer Wagner took Gonzalez to the Seminole County Jail, but testified that no one qualified to perform an alcohol breath test was present, so he just checked the box saying that she tested above a .08, the legal limit, suspending her driver's license, booked her into jail, and left. 2 months later, she was caught driving on the wrongfully suspended license. But now, with the new information, Judge Schott determined that her license should have never been suspended in the first place, as her DUI was only possible because the officer had perjured himself.
If I could be heard on that matter, I was going to ask... Before you go there,
I want to be enlightened. I didn't think your license got suspended for 6 months just for getting arrested for a DUI.
It was a mistake, admittedly, by Michael Wagner.
I know.
Who testified to that today.
He caused her to have her driver's license suspended for at least a few months, and now get arrested.
Yes, he did, Your Honor.
For nothing. Yeah. So you're going to no process that case, or am I going to get mad at you today?
Perhaps you can get mad at me, Your Honor, but at this point, the only thing that we're willing
Did you
to
hear
do,
the
Your Honor,
uncontroverted testimony of this officer?
Your Honor,
Yeah.
regardless of...
Tell me your position.
Yes, Your Honor. The DMV is in charge of suspending licenses.
Yeah,
They
when
receive a ticket from
officers
the
lie to them,
Correct, Your Honor, and that's why patrons...
then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is not true.
I'm dismissing.
The state's position.
I'm dismissing.
You cannot summarily dismiss, Your Honor, without a motion for us to be able to respond to.
No, I'm dismissing the charge. You can appeal me.
We will, Your Honor. Please provide us a written order.
No, I'm dismissing the charge.
So there will be no court minutes or whatsoever.
Sua sponte, based upon this record. And that case has the same record as this case. So take it up on appeal with him lying about it and getting
It's
her
not lying,
license
Your Honor,
suspended.
and I won't let that be said today. He admitted to the mistake today. Patrons and people who have
This whole
identifications
case
and
was
driver's
fishy,
license in the state of
and I
Florida
have no idea how
have to
you know
keep
what?
their address on file.
You know what?
The state intends to amend the charge and proceed on no valid.
I'm rescinding the sentence. I'm granting the JOA.
So you're granting it because you don't agree with the state's decision on
I'm
the other
granting
charge?
JOA in fairness.
In fairness,
You
because
got
you
it.
don't like the state's decision today, Your Honor, on the case?
No, you're not. No, I've reconsidered. I've reconsidered all of the testimony and the evidence. And you know, now
And the
that I
state would
consider,
like to be heard on
now
that
that I
matter.
consider what Officer Wagner testified to and how many times he basically tripped over himself unnecessarily just to arrest this lady with no real probable cause. We should have had a suppression hearing. I'm granting the motion for JOA.
Then the state would like to be heard on that matter, Your Honor, as they're entitled to be heard.
Sure.
Today we've proven, as Your Honor initially indicated, until such time as the state was not able to tell you why we're proceeding on the charge that we were proceeding on, the state intended to amend that to either a civil infraction and or a no valid, but the state needed time and intended to do that. However, in this particular case, there was ample testimony as to the fact that the defendant's own statement that she was in possession of alcohol and she drank it. There was testimony uncontroverted from the defendant that was in fact alcohol and she normally doesn't. This is again evidence, direct evidence, and not circumstantial evidence. Furthermore, there was bad decision making, there was balance, there was sway issues, and everything else.
JOA for the defendant. You're done. But you still have this other criminal charge. I'm not dismissing that. The DeWillis, we're going to go full bore. We'll get DMV people in here. We'll get Officer Wagner back here, and we'll find out why your license was suspended if somebody broke the law to cause your license to be suspended. And that's the route you wanted to go.
No, Your Honor, that's not
really
the route.
wrong.
Is that
Absolutely.
another case on your docket? I
Yes,
heard
it
that
is
was
on
your
my
docket
docket.
in both. Okay, I just wanted to make
We'll
sure.
see where that goes.
Okay.
Motion JOA is granted.
Your Honor, I believe it would be judgment notwithstanding a verdict.
Judgment notwithstanding JOA.
And you're not going to provide a written order on that?
Nope. It's in the minutes. You want to appeal me?
The judge absolutely has the authority to overrule the jury's verdict, but it is rarely done. The morning after this incident, the judge changed course again and filed a 4-page order saying that he was granting a motion for a new trial, although no one had made such a motion. Ms. Gonzalez's defense says that because she was acquitted, any retrial would violate her right to not be prosecuted more than once for the same offense. And after all of this, Judge Schott was removed from criminal trials. He was then reassigned to a civil docket. In a statement, he said that he sticks by his decision, but he admits that he shouldn't have gotten so mad at the prosecutor, or granted a non-existent motion for a new trial after apparently acquitting the driver. And in the end, the officer maintains that it was merely a mistake. But I'd like to know what you think, as this case does not appear to have been appealed or retried, nor does it seem that Ms. Gonzalez has filed a civil suit against the officer or prosecutor. And of course, the officer was never charged with perjury. Let me know what you think in the comments down below.
Some people were swearing.
Absolutely.
And would you describe other people's demeanors as upset or angry?
I don't know if you've seen anybody be killed, but it's upsetting.
The answer is
Yes, I was just going to object, Your Honor.
as argumentative, and you can proceed. We are outside the hearing of the jury. Ms. Hanson, I'm advising you, do not argue with counsel. And specifically, do not argue with the court.
Is the cameras off? Are the cameras off?
No, they are not. We are on the record.
Okay.
You will not argue with the court. You will not argue with counsel.
Mm-hmm.
They have the right to ask questions. Your job is to answer them.
I was finishing my answer.
I will determine when your answer is done.
Okay, well...
And so, do not argue with the court. Do not argue with counsel. Answer the questions. Do not volunteer information that is not requested. The attorneys for the state have redirect. They can ask you questions if they think that certain things were left out.
Okay.
It is counsel's prerogative to ask you leading questions and for you to answer those and not volunteer additional information.
Okay.
Are we clear on this?
We're clear.
Thank you. Come back tomorrow at 9:30.
Thanks for watching. If you have a video, use the submit link in the description or pinned comment. If you enjoyed this one, subscribe and hit the bell for future content, and check out our other channels, Lady Lackluster and The Odd Side. Remember to like, share, and leave a comment about what you think of this interaction. It's the easiest way for you to help expose corruption and misconduct. Merchandise is available using the links below. Join the Lackluster family for just $1 if you'd like to further support the channel. Get a Lack logo next to your name, custom emotes, and early access to videos. I look forward to seeing you in the next one. All links are down below.